Hello and welcome to today's webinar. My name is Robbie and I will be in the background answering any WebEx technical questions. We have a few housekeeping items before we get started. If you experience technical difficulties joining the WebEx session, please dial 1-866-779-3239, or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in a listen-only mode, and as a reminder, this event is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. We encourage you to submit written questions at any time during the presentation using the Q&A panel at the bottom right of your screen. Please type your questions into the text field and hit send, and please keep the drop-down as all panelists. I would now like to hand it over to your first speaker for today, Nicole Reifman, partner at MBHB. Nicole, you now have the floor.
Thanks, Robbie. Please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note there are two randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both of these poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we'll attempt to address submitted questions at the end of the webinar. If time does not permit, we'll respond offline after the webinar. Eric Moran and I will be talking today about a mid-year review of the top stories in trademark and copyright law. And what we're going to do is discuss highlights from late 2019 through mid-2020. Eric is going to kick us off with discussing recent trademark and copyright cases before the Supreme Court. I'm then going to discuss some recent federal court decisions of note. I'll then talk about some interesting recent TTAB decisions of note, and Eric's going to finish with recent rules and examination guides. So with that, I'm going to turn this discussion over to Eric to start off with the Supreme Court.
Thanks, Nicole. Hello, everyone. I hope everybody is healthy and safe, and I also hope that no one else can hear my neighbor mowing his lawn outside my window because it's getting pretty loud in here. We're going to start off, as Nicole mentioned, with talking about some recent Supreme Court cases involving trademark and copyrights. The first will be Romag v. Fossil, then Georgia v. Public Resource Org, then Lucky Brand Dungarees v. Marcel Fashions, and we'll finish up with the USPTO v. Booking.com case. So starting off with Romag. This opinion came out on April 23rd of this year. It was authored by Justice Gorsuch, and it addressed the question of whether willfulness is a prerequisite for an award of an infringer's profits for a violation of Section 43A of the Lanham Act. This is the likelihood of confusion provision of the Lanham Act. And so this case arose when Romag and Fossil entered an agreement by which Romag was supplying Fossil with magnetic fasteners for use in Fossil handbags. Fossil's factories in China, however, ended up using what Romag alleged were counterfeit Romag fasteners. So Romag sued Fossil, alleging trademark infringement, and that Fossil falsely represented that the counterfeit fasteners were actually Romag fasteners. At district court, Romag won a jury trial, and although the jury found that Fossil acted with quote-unquote callous disregard to Romag's rights, the jury did not find that Fossil acted willfully. Nonetheless, Romag sought an award of Fossil's profits for the infringement, but the district court refused, citing Second Circuit precedent that requires the plaintiff to prove willfulness when seeking profits. So in light of a circuit split on the issue, the Supreme Court granted cert. This case really focuses on 15 U.S.C. Section 1117, which provides for recovery of violations of rights under the Lanham Act. Specifically, 1117A was at issue in this case, and it's instructive to turn to the language of that statute, which states, when a violation of any right of the registrant of a mark registered, a violation under Section 1125A or D of this title, or a willful violation under Section 1125C of this title shall have been established, the plaintiff shall be entitled to recover defendant's profits. So breaking down that language a little bit, Section 1117A identifies a number of situations in which profits can be awarded for trademark infringement. The first under this statute is a violation of any right of the registrant of a registered mark. The second is a violation under Section 1125A, which is the likelihood of confusion or false designation of origin provision of the Lanham Act. And that's the section under which ROMAG brought its suit against Fossil. Third, for a violation under Section 1125D, the cyber piracy provisions of the Lanham Act. And fourth, for a willful violation under Section 1125C, which is the dilution provisions of the Lanham Act. So Justice Gorsuch wrote the opinion for the court for this case, and he said pretty forcefully after reviewing that language, immediately this language spells trouble for Fossil and the precedent on which Fossil relied. Justice Gorsuch continued, the court does not usually read into statutes words that aren't there, and that it's in temptation when we are doubly careful to avoid when Congress has, as here, included the term in question elsewhere in the very same statutory provision. So he was referring to the use of the term willful in 1117A's reference to the dilution provision, but not in 1117A's reference to the likelihood of confusion provision. And so based on this language alone, the language of the statute alone, the court found that willfulness was not required for a recovery of profits in a likelihood of confusion claim. Interestingly, the court also went through a number of other instances in which the Lanham Act talked about mental states or mens rea of actors when awarding various remedies to plaintiffs. For example, 1117B trebles recovery for parties that are acting or in cases where parties acted intentionally with specified knowledge. 1117C increases statutory damages for willful violations. 1118 relates to destruction of infringing articles for willful violations of the dilution statute. And 1114 talks about printers and publishers and innocent infringements for printers and publishers. And 1114, the court pointed out, limits liability in certain cases where there are innocent infringers. So the court pointed out that although it's not a requirement, willfulness is still a very important part of analyzing an award of profits. In fact, Justice Alito filed a concurrence, and he would have clarified this further. He would have held that willfulness is a highly important consideration in awarding profits, although he agreed that it wasn't required. So in terms of takeaways from this case, monetary recovery in trademark infringement suits can be difficult generally, but this case makes it a little easier for some plaintiffs and some circuits to recover, to obtain monetary recovery. Proving profits is often easier than proving damages. Damages requires causation. For example, proving a plaintiff's damages requires proving that the infringement caused harm, proving the value of the harm caused. And it may be hard to show how an infringement caused lower sales, or how an infringement caused those sales to go lower, or how much an infringement caused the value of a brand to decrease. Whereas with respect to profits, under 1117A, the plaintiff carries the burden of showing an infringer's sales, generally done through documents and other materials obtained during discovery. And then the burden shifts to the defendant to show costs and deductions. So using an infringer's sales as a starting point can be advantageous for a plaintiff. It may not be that much easier, but it does seem like this case makes it a little bit easier for monetary recovery in some situations. Okay, turning to the second case we want to talk about, Georgia v. Thepublicresource.org. This case was decided on April 27th. The opinion was authored by Justice Roberts, and it was a 5-4 opinion. The question that the court addressed is whether the government edicts doctrine, now this is a copyright case, so whether the government edicts doctrine extends to and then thus renders uncopyrightable works that lack the force of law, such as annotations in the official code of Georgia annotated. Now that was the work that's at issue in this case. So just a little background. The state of Georgia publishes its official code as the official code of Georgia annotated, and the code provides the text of all the statutes in Georgia that are in force, and also includes explanatory materials along with those statutes. And these include summaries of court opinions applying statutes, summaries of law review articles related to those statutes, legislative history of the statutes, things along those lines. The preparation of the Georgia Code is overseen by a body called the Code Revision Commission, which was or is a commission created by the Georgia legislature, and it's largely comprised of members of the Georgia legislature and staff from the legislature. The commission doesn't actually do the writing of the annotations itself. It actually outsources that preparation to a third party. Here it was Lexis that actually did it. But the commission approves, and the Georgia legislature ultimately approves the annotations written by Lexis and before they're published. So the issue here arose when a nonprofit, Thepublicresource Org, provided the public with access to the Georgia Code and the annotations. It allowed the public to download the materials and access the materials without charge. And so the commission got wind of this and brought suit against Thepublicresource Org for copyright infringement. So the case made it to the Supreme Court, obviously, and Justice Roberts authored the opinion of the court, and he looked right to the government edicts doctrine. Now, this is a doctrine that limits copyright protection for works created by legislators and judges based on the idea that those officials, when acting in the course of their official duties, are not considered authors under the Copyright Act. So copyright would not attach to materials that they produce. So the court went through the history of this doctrine in deciding this case and found that the doctrine derives from 3 copyright cases decided in the 1800s, Wheaton v. Peters, Banks v. Manchester, and Callaghan v. Myers. The court went through these 3 cases. It was a pretty interesting analysis. The first case was Wheaton v. Peters, and in this case, which was decided in 1834, the third reporter of the Supreme Court, Wheaton, sued the fourth, asserting copyright protection in the justice's opinions contained in the reporter. In this case, Wheaton argued that these opinions were protectable because they were new, original, and more elaborate than law or custom required. Wheaton also asserted that the justices were authors and that they assigned their ownership interests to him. The court disagreed and said that no reporter can have any copyright in written opinions of the judges, and the justices cannot confer those rights or any copyrights in those opinions on any reporter. So the next case was heard about 50 years later. It also involved an official reporter. This case was called Banks v. Manchester, and in this case, the reporter asserted copyright protection not only over a judge's opinions, but over case statements and syllabuses and headnotes that were also prepared by the judges. The court found that copyright protection attached to both the opinions and the explanatory materials created by the judges. And the court said that all of the work done by the judges constitutes the authentic exposition and interpretation of the law, which, binding every citizen, is free for publication to all. So what the Banks v. Manchester court found was that everyone has the right to access materials created by judges, whether they're actually judicial opinions that carry the force of law or explanatory materials for those opinions, which actually don't carry the force of law, but yet still are prepared by the judges. So the third case, Callaghan v. Myers, involved similar issues, but had a new nuance. Callaghan also involved the idea of, well, the issue of a reporter that authored explanatory materials. So in this case, the reporter authored headnotes, syllabi, tables of contents, and other explanatory materials related to the court's opinions. And the Supreme Court in Callaghan found that it was perfectly acceptable for the reporter to retain copyrights to materials that the reporter has prepared, but the reporter does not get to maintain copyright protection over materials prepared by the judge. So Justice Roberts, in reviewing these cases, found that they set forth a straightforward rule, and that judges make and interpret the law and cannot be the author of works they prepare in the discharge of their official judicial duties. And according to the court, this applies to both binding works, such as legal opinions, and to non-binding works, such as headnotes and syllabuses. Of course, this rule does not apply to materials authored by reporters. So applying this rule or expanding this rule from judges to legislators, the court in Georgia, the Public Resource found that under the government edicts doctrine, copyright does not vest in works that are created by judges and legislators in the course of their judicial and legislative duties, regardless of whether the material carries the force of law or not. So here, Georgia could not claim copyright over the annotations and other explanatory materials that were found in the Georgia Code, because that material was drafted by the Georgia legislature conducting its legislative duties. Justice Thomas wrote a lengthy dissent in this case in which he said that he would have found that the government edicts doctrine does not apply to the notes and only applies to judicial opinions. Likewise, Justice Ginsburg dissented, and she would have found in this case that the annotations found in the Georgia court were not actually created by legislators in the course of their judicial or legislative duties, mainly because they are not created contemporaneously with the actual statutes themselves. So in terms of takeaways here, the takeaways from this case are probably less about IP law and more about the importance of annotations for statutes and about equal access to the law for all readers. Justice Roberts went into this in some length in the opinion and said that he made the case that the annotations, in many cases, the annotations found in the Georgia Code are important to understandings of the statutes found in the code. And these annotations advise the public, especially in this case, that many of the statutes in the Georgia Code had been found unconstitutional, yet were still remained in the code because the legislature hadn't narrowed them or repealed them. As examples, Justice Roberts gave qualification fees for political candidates and criminalization of various categories of consensual sexual conduct. Justice Roberts felt that those reading the statutes without access to the annotations may not understand that such laws were no longer enforceable. So according to the court, the annotations, at least found in the Georgia Code, were necessary to supplement the statutes and necessary to the understanding of the law. Okay, so the next case that we want to talk about is Lucky Brand Dungarees v. Marcel Fashions Group. This came out on May 14th of this year. It was a unanimous opinion authored by Justice Sonia Sotomayor, and it addressed the question of whether Lucky Brand's failure to litigate a defense in an earlier suit between the same parties barred Lucky Brand from invoking that defense in a later suit. So it's helpful and probably necessary to go through the case history here. The parties had a long and tortuous history of litigation dating back to 2001, and the history involved 3 separate cases that were filed between the parties. Marcel filed the first case in 2001 and alleged that Lucky Brand's use of the term "get lucky" infringed Marcel's "get lucky" mark. The parties settled that case according to a settlement agreement in which Lucky Brand agreed not to use "get lucky," and Marcel released Lucky Brand from its claims against it. Lucky Brand brought the second case in 2005 against Marcel, alleging trademark infringement. Marcel counterclaimed against Lucky, alleging that Lucky continued to use the "get lucky" phrase in violation of the parties' settlement agreement that resulted from the 2001 case. With respect to that settlement agreement, Lucky Brand raised the release provision of that agreement twice in the second case. First time was in a motion to dismiss Marcel's counterclaims, and Lucky asserted that those counterclaims were barred by the release provision. The court denied that motion, and then Lucky raised that defense in its answer to Marcel's counterclaims. Lucky never raised that defense again. It was never litigated in this case, and the court never rendered a decision with respect to the release provision of the settlement agreement or whether that was a proper defense for Lucky Brand here. The second case ended up being decided in Marcel's favor. The court ended up enjoining Lucky Brand from using the term "get lucky." So that brings us to the third case. The third case was filed by Marcel in 2011 and alleged continued infringement of its "get lucky" mark, but this time it was through Lucky Brand's use of the word or phrase "lucky" as opposed to "get lucky." So slightly different mark at issue here from Lucky Brand's perspective. So after some procedural back and forth in the third case, which involved an appeal, Lucky Brand eventually moved to dismiss Marcel's claims, and it raised the release clause from the settlement agreement defense for the first time since its answer in the 2005 case. Marcel responded by arguing that Lucky Brand was precluded from raising that defense because it was a defense that could have been fully litigated in the 2005 case, but Lucky Brand chose not to do so then. So the district court granted Lucky Brand's motion to dismiss. On appeal, the Second Circuit disagreed and raised the idea of defense preclusion and said that defense preclusion prohibited Lucky Brand from raising the release defense in the 2011 case because it was an unlitigated defense that it should have raised earlier against Marcel in the 2005 case. So with respect to defense preclusion, the Second Circuit said that defense preclusion bars a party from raising a defense where a previous action involved an adjudication on the merits, the previous action involved the same parties, the defense was either asserted or could have been asserted in the previous action, and the district court in its discretion concludes that preclusion is appropriate. So the Second Circuit had a whole factor test laid out for when defense preclusion applies. And the Supreme Court granted cert to resolve a circuit split regarding this defense and when, if ever, claim preclusion applies to defenses raised in later suits. So Justice Sotomayor framed the question at issue in terms of kind of the two distinct preclusive doctrines that most of us are probably familiar with. Issue preclusion, aka collateral estoppel, which precludes a party from relitigating an issue that was actually decided in a prior case and necessary to that judgment. And the second being claim preclusion, or res judicata, which prevents parties from raising issues that could have been raised and decided in a prior action, even if they were not actually litigated. So the court really didn't discuss the viability of the concept of defense preclusion. It really said that the case either had to fit in, any sort of preclusion had to fit under either issue preclusion or claim preclusion. And of the two, the court found that claim preclusion was the most appropriate because this defense was never actually litigated in the prior case. And so applying claim preclusion, the court would bar the defense only if the two actions, the prior case and the current case, share a common nucleus of operative facts. So here, the court found that there was no common nucleus of operative facts. The 2005 case involved the get lucky mark, Lucky Brand's use of the get lucky mark, whereas the 2011 case involved just the term lucky. And the 2011 case actually involved conduct that occurred after the 2005 case. And claim preclusion generally does not apply to activities that occur after the prior litigation. So the court did not bar Lucky Brand's use of that defense. And interestingly, the court specifically noted the importance of its decision with respect to trademark disputes. And I'll just read this quote from the court. This principle, the idea of claim preclusion, takes on particular force in the trademark context, where the enforceability of a mark and the likelihood of confusion between marks often turns on extrinsic facts that change over time. As Lucky Brand points out, liability for trademark infringement turns on marketplace realities that can change dramatically from year to year. So the court, by not precluding this defense, because it wasn't litigated in the 2005 case, the court is recognizing that trademark rights, the scope of protection of trademarks, and potential confusion can change very quickly in a dynamic marketplace. For trademark infringement, there are 14 DuPont factors, so there are a lot of moving parts that can all change very, very quickly in trademark disputes, and the court was clearly recognizing that in this case. This case is also interesting in that the court never really addressed the issue of when or if ever claim preclusion can be applied to defenses. The court kind of skipped in that question and just analyzed the facts of this case, but that question has a couple of different policy considerations. If claim preclusion can actually apply to defenses, that would require defendants to litigate all possible defenses to final judgment, and potentially that would increase litigation costs, increase burden on the courts, and would be a different approach certainly than what Lucky Brand attempted here. But the new claim preclusion has some important policy advantages, and that is it requires parties to resolve all possible claims and issues and defenses at the earliest possible opportunity. Therefore, parties can avoid the type of back and forth litigation or continuous litigation that the parties here engaged in. In any case, the court didn't decide that and just decided this case on sort of the narrow grounds that it was presented with the facts between these two parties. Okay, the last case we want to look at from the U.S. Supreme Court is the USPTO v. Booking case. This opinion just came out on June 30th. And interestingly, this was the first case in which oral argument was open to was available. The audio of oral argument was available to the general public because of the COVID situation. So a lot of people got to hear these arguments as they occurred. In any case, the court in this case looked at whether an online business's addition of a generic top-level domain, so .com, to an otherwise generic term, booking, can create a protectable trademark. So just a quick background, booking.com provides online travel reservation services under the booking.com brand and via its website, which resides at booking.com. And Booking.com attempted to register Booking.com trademarks with the USPTO, and the examining attorney at the USPTO refused registration for each, finding the marks generic for online reservation services for travel, tours, lodgings, and the TTAB affirmed those refusals. So Booking.com then appealed those refusals or the TTAB's affirmance to the U.S. District Court in the Eastern District of Virginia, which allowed it, because it appealed the decision to the district court, Booking.com was allowed to submit other evidence and make other evidence of record, which it would not have been able to do if it had appealed this case directly to the Court of Appeals for the Federal Circuit. So Booking.com submitted new evidence of consumer perception in the form of consumer surveys to the Eastern District of Virginia, and that evidence was pretty effective. Apparently, the district court relied in significant part on that evidence and found that Booking.com, unlike the term booking by itself, was not generic. The district court found that consumers primarily view Booking.com as descriptive of booking services available at that domain name, and did not consider Booking.com to be a generic term for those services. According to the district court, it went even further to say that Booking.com has actually acquired secondary meaning or distinctiveness as to hotel reservation services, and therefore that mark, according to the Eastern District of Virginia, was registrable as a trademark. So the USPTO appealed genericness to the Fourth Circuit, which found no error in the district court's decision, and the Supreme Court granted cert. And the way the Supreme Court put it was, in its opinion at least, was it was deciding whether there is a nearly per se rule against trademark protection for a generic .com term, which it considered Booking.com to be. So Justice Ginsburg wrote the Booking.com opinion for the court and began by defining a generic term, or confirming the definition of a generic term as the name of a class of products or services. And she confirmed that generic terms are ineligible for federal trademark protection because generic terms cannot serve to distinguish one party's goods or services from another party's. And of course, the court also found that the term booking was generic for hotel reservation services, so the question really revolves around Booking.com. Justice Ginsburg pointed out a few other areas of agreement between the parties. Interestingly, for a compound term, the distinctiveness inquiry, according to the parties in the court, is focused on the term's meaning as a whole and not its terms in isolation. So the distinctiveness inquiry here has to focus on Booking.com and not on whether Booking is distinctive and whether .com is distinctive, but it has to be whether the entire compound term is distinctive and has a particular meaning to consumers and is capable for consumers of distinguishing parties' goods or services in commerce. So one of the court addressed what is the proper test for determining whether a term is generic, and this was argued at length during oral argument and during the parties' briefing, and the court found that the primary significance test was the proper test for determining genericness, and the primary significance, in fact, the primary significance of the registered mark to the relevant public. And this was an issue because the USPTO argued that the primary significance test is only found in one place in the Lanham Act, and that is under the section of the Lanham Act that dealt with cancellation of marks that are already registered. But the USPTO rejected the Supreme Court rejected the USPTO's position on that issue. And according to the Supreme Court, primary significance equals consumer perception. The Supreme Court asked, does Booking.com to consumers, does Booking.com mean travel reservation services? And the court asked some hypothetical questions. Would consumers appropriately refer to other travel reservation service providers such as Travelocity as a Booking.com, or would consumers ask someone for their favorite Booking.com provider? And the court really found that wasn't the case. In finding that the primary significance test is the proper test, the court rejected the USPTO's Goodyear case. So this is a case that the USPTO argued supported its position with respect to Booking.com. In the Goodyear's case, it's Goodyear's India Rubber Glove Manufacturing Company v. Goodyear Rubber Company. That case involved the addition of the word company, the generic term company, to another generic term. And the Supreme Court found in the Goodyear's case, this was from 1888, that the addition of the word company to another generic term could not create a word or a mark that had trademark eligibility. So the USPTO cited this case often and discussed this case often with respect to Booking.com. But the court interestingly distinguished the Goodyear case from the Booking.com situation and says that a generic .com term may be source identifying, actually, unlike the term at issue. It was actually Goodyear Company, unlike that term, because the generic .com term actually identifies a particular website that only one entity can occupy at a time and offer services at a time under that mark. And so the court distinguished Booking.com from the USPTO's Goodyear case under that rationale. The court also was not too concerned that giving exclusive rights to Booking.com would prevent competitors from using the term booking, which the court had already decided was a generic term. And certainly Any term that's registered as a trademark doesn't preclude generic or descriptive uses of that term. And the court also focused on the idea that of the scope of protection of Booking.com, and that it would likely have a very narrow scope of protection based on other similar marks in the field. Interestingly, the court's decision, and the court talked about this, the court's decision did not jeopardize the registration of a number of other generic .com marks that the court had registered already, or excuse me, that the USPTO had registered already. So in the USPTO, there were a number of these Booking.com type marks already out there that were registered. And the court noted that its decision doesn't jeopardize or doesn't open the door to cancellation of these other registered marks. Justice Sotomayor filed a concurrence, and she questioned the reliability of the survey evidence that was used by the Eastern District of Virginia. And Justice Breyer authored a dissent. He would have found along the lines of the Goodyear case, in which generic .com marks would, under his rationale, would necessarily be generic because they consist simply of a generic term and a corporate designation. Okay, that's it for the U.S. Supreme Court cases. I'm going to throw it back to Nicole for federal court cases.
Thanks, Eric. And just to let everybody know, we have not gotten to the poll questions yet. We're going to get through both in the latter half here of the presentation. All right, so I'm going to go through two federal court cases. The first one here is CFA Institute versus the American Society of Pension Professionals and Actuaries. This took place in the Western District of Virginia. And before I jump into these bullet points on this slide, I want to give you a little bit of background. Both parties here at issue were organizations in the business of certifying and training financial advisors. So the plaintiff catered its services to financial advisors generally. They have a program that is called the CFA program. And in the 70s, the plaintiff applied and received federal registration for CFA. And the services were for association services, namely the promotion of interest and professional standards in the field of financial analysis. So a broad description. The ARA, so the defendant, also trains and educates those providing financial services. However, the defendant is in a niche field here. They're providing certifications and education to financial advice for employers on the retirement plans that they offer to their employees. So pretty specific. There's a lot less required to obtain the certification provided by the defendant. And what happened here was the defendant sought to register their mark, which was CPFA, not CFA, but you can see the closeness there. Once that mark was published, the plaintiff opposed it. And so then we found ourselves eventually in the Western District of Virginia. And now up to the bullet points here. What the defendant wanted was that the plaintiff, they asked the court to restrict the plaintiff's registration, their description of services, to carve out this retirement financial planning at the employer level. And they said if you put some type of language in there, the plaintiff's description, that carves that niche out, that'll avoid confusion between the two marks. The court, however, dismissed this claim, and the main reason for the dismissal was that there was no legal support for the proposition that Section 18 of the Lanham Act would apply to a civil action. So they said this is not for us to do. However, they also then noted that even if it was for us to do, it seems like the defendant has failed to allege any facts that would make their claim plausible. For example, the defendant failed to allege any facts that, if proven, would demonstrate how this proposed restriction would actually affect a likelihood of confusion analysis in the marketplace. So the defendant didn't give anything to back up their proposed restriction and how that would prevent confusion. Moreover, the defendant didn't even provide any facts that would show that the plaintiff is not using its mark with respect to that niche, in addition to the other financial services they provide. So here the defendant just did not have good arguments all around. The second federal court case I'm going to talk about is Highleet versus Hybrid Athletics. And this one started out as a kind of garden variety likelihood of confusion dispute between two parties at the board. And these are the two marks that were at issue. We call them the H marks. The TTAB held there was a likelihood of confusion between those two marks. And then on appeal, Highleaf argued that the board had erred by considering those two H marks, these two here, and not the composite common law mark that I've replicated here. It's a little fuzzy, but so they argued that's the mark you should have compared with respect to ours, not these two here. The court, however, found that Highleaf had waived this type of argument because they didn't raise it before the board. So before the board, the two entities were only arguing the two marks I showed you on the prior slide. This composite common law mark was not brought up by Highleaf and was not argued by Highleaf. Highleaf didn't dispute that fact. It didn't dispute that it failed to raise this composite common law issue before the TTAB. However, Highleaf said that the board, sua sponte, raised this issue when it rendered its final decision. So it mentioned the composite common law mark in the final decision. And Highleaf said, the board brought this up, and now, I want to appeal and discuss how my mark is different from the composite mark. The CAFC said, well, absent limited circumstances, federal courts don't consider issues that were not discussed in the court or the board below. So here, because that's our holding and that's our standard, the one remaining question is, do we have limited circumstances in this situation? CAFC determined no, there were no limited circumstances. This composite mark was certainly around during the time that these two marks were being discussed. Highleaf could have raised it by themselves during the opposition proceeding. And so no injustice, there was no injustice to Highleaf by not having, because they had the option to argue it before the board. Now, interestingly, the CAFC, while they affirmed the board's decision, they declined to address the board's analysis. And that's because with respect to those two, the comparison of those two H marks, and that's because Highleaf did not bring that issue, that comparison before the CAFC. All right, here is our first poll. Please note for those seeking CLE credit, there is a poll question module that has opened up on your screen. And what you'll do is enter the word that you see in quotes here on this page, and then click submit. And we're going to keep this up for a little bit longer. I'll pause for a second here to allow you to enter and click submit, the term that you see on the slide. Okay. Next, I'm going to move through some interesting TTAB cases of note that occurred in the latter half of 2019, some in the early part of 2020. The first one is Enri Oep Enterprises. And the issue here was a functionality refusal. Now, the trademark was sought for part of an umbrella, and in case you thought one could not further perfect the umbrella, you would be wrong, because here the applicant had sought to obtain design patent, utility patent, and trademark protection for this umbrella. Now, I work both in patents and trademarks, and I do see products where a client could seek protection in all three of those categories, it can be powerful. You can obtain protection in all three groupings, but you do need to be careful, and this case is a nice example of why you need to be careful. What OEP wanted was seeking trademark protection for was this mesh of the lower canopy. So this is a dual canopy umbrella. There's a top canopy in the middle part, and what you're seeing here in the picture, this is a trademark application, was the mesh portion, which comprised the lower canopy. OEP had both design and utility patent applications. And there were a number of issues here. The first issue that the TTAB noted was that the drawing that was submitted for a trademark application depicts, the drawing itself depicts the mark you want to register. And if there's unclaimed subject matter, that needs to be shown in broken lines. Here you can see the entire umbrella was in solid lines, and the board concluded that, you didn't take out anything that would be functional. OEP didn't dispute that, let's say, the handle, the shaft, the ribs of an umbrella are all functional, and they're all shown here in solid lines. Even the upper canopy serves a function to block the rain or sunlight. So that was the first issue. But putting that aside, so let's say they properly only were claiming the mesh canopy. Even that, the board held would receive the functionality refusal here. And that's because of the language that was used in the utility application. OEP, like I said, did have a design patent for the umbrella design. And the board agreed that is evidence of non-functionality. And it's strong evidence of non-functionality. But the mere existence of a design patent is not dispositive on this functionality issue. And here, the utility application language seemed to really kill the argument that the mesh was not functional. And I'll give you some examples of what was stated in the utility patent application. The mesh material provides strength to the entire first canopy. It helps to keep the first canopy portion taut. The mesh portions are easier to sew along the panel seams, and there's less waste of material as compared with a die-cut vent when you use this mesh. Also, the mesh provides for significantly greater airflow than prior art designs. So those were all statements made in the utility application. And those seem to be convincing to the board that, that this mesh has a number of functional purposes and that the mark as a whole is functional. So my advice here and the moral of the story is, if you're not the practitioner who's preparing both the patent and trademark applications, you should most definitely, as the trademark attorney, ask to review or coordinate with the patent attorney to do a final review of the draft application before it's filed, and to make sure there aren't issues when you're trying to coordinate trademark and patent protection. The next case is another interesting patent and trademark interplay case, but goes to a different issue. This one is a merely descriptive refusal, Enri Oep. And here the mark is sequencing by binding. Often, this can often happen with respect to someone who can achieve or can attain both patent and trademark protection, where you're the innovator, you've come up with the new thing. And as the first person to come up with this thing, you get the additional benefit of being able to coin certain terms that might be associated with the thing. But again, you have to be calculated and coordinated between the patent and the trademark applications to make sure you're not harming your trademark application in the way you're describing these new coined terms. So here, the board held that dictionary definitions, industry articles, applicants' patents, and their patent applications all showed that the proposed mark, sequencing by binding, immediately conveyed information to the target audience regarding the recited services. And that type of immediate conveyance brings about a merely descriptive refusal. So the way these coined terms were discussed in the patent application hurt the trademark application. This one I'm just going to go over quickly. Hole-in-One Drinks versus Michael Lajte. Here we have a bona fide intent to use issue, which is interesting. You have two business partners, yet one alone filed the intent to use application. And later on down the road, the TTAB held that two business partners jointly had this bona fide intent to use the mark at the time of filing. So your application should have been filed in the name of the joint applicants, or if, you know, those joint applicants have some type of corporation or LLC that's been formed in the name of that entity. But this, one of the two people could not file alone and was deemed to not have this bona fide intent to use because you didn't include the other person. The only other thing I'll say with respect to this one is if you want an interesting / entertaining read, I recommend checking out the filings for this case. There's some interesting commentary given by Mr. Lajte. The last TTAB case I'm going to go over is Wirecard versus Striatum Ventures. And I feel like I've been discussing cases where, you know, either the courts or the board are just shooting down marks, and this is, we'll end on a happier note. Here, the TTAB, the issue was use, and TTAB held that the use requirement was met. The situation is Striatum obtained a registration for their mark in October of 2015, and they went through the Madrid Protocol to obtain this registration. 3 years and 2 days later, in 2018, Wirecard filed a petition to cancel their registration on the grounds of abandonment. They hadn't used the mark yet. And the parties stipulated that from the issuance of the registration date in 2015 through the date of the stipulation, which went all the way, you know, past 2018, and went all the way up to May 28, 2019, the parties stipulated, you're right, no goods and services have been sold in the U.S. under Striatum's mark. TTAB held that use in commerce is not required in order to obtain this Section 66 registration, but you have to, if you're seeking an extension of protection, you have to declare your intent to use the mark in the United States. And abandonment would occur when use has been discontinued with no intent to resume the use, and intent not to resume can be inferred from the circumstances. And then here, Striatum had an additional uphill battle because non-use for 3 consecutive years is deemed to be prima facie evidence of abandonment. And like I said at the beginning, the party that was seeking to cancel their mark waited 3 years and 2 days, and they saw that there had been no use. So Striatum did have to, the burden was on them to contest this abandonment claim. All right, so the question became, were the activities that Striatum undertook those that a reasonable businessman with a bona fide intent to use the mark in the United States would have undertaken? And Striatum submitted a number of declarations, both their own declarations and from third parties, that were able to convince the board that their activities did rise to that level and showed they had a bona fide intent to use the mark in U.S. commerce. So their mark was not canceled due to abandonment. All right, this is the second poll question. Just like the first, if you're seeking CLE credit, the module should now be opened for you to type in the answer to the poll question, and you'll see that answer on this slide within the quotation marks. Go ahead and enter that word into your poll question, hit submit, and you should be good to go. And I will pause before handing it over to Eric. So I'll pass the ball over to Eric now to finish this up.
Thanks, Nicole. I'll wait just a few more seconds here. Okay, we're going to finish up by talking about recent rules and examination guides that have been issued this year by the USPTO, or the U.S. Trademark Office. And these are examination guide. The first is examination guide 120, which deals with mandatory electronic filing and specimen requirements. And The second one is Examination Guide 220, which deals with geographic wording related to cheeses and processed meats. Now, the first examination guide probably affects every single person that practices before the trademark office. The second is very industry and trademark specific, but they're both very interesting. So we'll at least talk through them a little bit here now. So with respect to the first examination guide, the office issued this in February of this year, and or at least it went into effect in February of this year, and it dealt with a number of different issues. But probably the two most important ones are not only mandatory electronic filing, but I think most people are already doing electronic filing to begin with. But the one that was maybe most talked about was that the Trademark Office changed the requirements for identification of trademark owners before the trademark USPTO, before the TTAB, and required that trademark owners now provide an email address at which they can be copied, like the actual owner itself can be copied in case counsel is not available, changes email addresses, or just as kind of a backup to counsel's email address. Now, as the rules were initially, as these guidelines were initially published, the wording of the guidelines required, and the guidelines required that the email address be kind of an in-house email address for the trademark owner. And it didn't have to be an in-house counsel, but it had to be an internal email address that the trademark owner checked. And the guidelines do not provide for any sort of redaction or masking or hiding of that email address. So there are all kinds of, among the trademark practitioner bar, there are all kinds of concerns about loss of privacy for trademark owners who are celebrities, for example, who wanted to remain private, or an increase in spam or solicitation sent by third-party vendors to trademark owners, which trademark owners already get a ton of this just via their paper email or their snail mail addresses, much less via an email address. And a lot of the solicitation is very misleading, right? They misstate dates of renewal to try to get trademark owners to renew early and to pay these third parties to renew their mark. So there was a lot of valid concerns about this rule. So right before it was to go into effect, the Trademark Office revised the rules and issued a revision and backed off a little bit the requirement that a trademark owner provide an internal address, and that address would therefore be public. The guidelines, as revised, stated that applicants and registrants needed to still include an email address for each applicant, but it may be an email address of the owner's choice in the owner email field of the trademark application, and it cannot be identical to the listed primary correspondence address of the attorney. So the office was basically saying that you could use an attorney's email address now for this internal email address. The guidelines did also talk about how that email address would be not shown in the status page of trademark, of the status page maintained by the Trademark Office TSDR, but it would be found if you drilled into the documents that were available via the TSDR page and went to the actual document as filed itself, you would someone could still learn the email address that was used for the owner's email address. But subsequently, the office has changed that, and the office now masks the email address, so you can't find the email address in TSDR currently. And if you drill into the documents tab of TSDR, those email addresses have been masked in the documents as well. So the office eventually addressed a lot of the concerns that were raised about this new requirement. The guideline 120 also made some changes to submissions of specimens of use, and this is in response to the office seeing an increase in the number of improper or inauthentic or sort of made up or mocked up specimens of use submitted by applicants and registrants in order to secure a registration or to renew a registration or keep a registration in force. So generally speaking, specimens of use for goods include photographs of goods showing the mark, or photographs of containers or packaging for the goods showing the mark, or screenshots of websites from which goods can be ordered where the website shows the mark. And then specimens for services are often websites and other advertising material, but largely websites that describe the services being offered under the mark and that also show the mark on the website. So the office has changed the rules for submission of specimens to require any time an applicant or registrant submits a website specimen, the website has to show the URL of the website that's being submitted, and it has to include a date, the date that the website was accessed or printed, which are it's pretty easy to add that information if a website is printable. A lot of websites these days don't kind of format right if you try to print them, and sometimes you have to do screenshots, and so sometimes this information needs to be added manually to the headers or the footers of those specimens. But the office also has changed even if photographs are used. So aside from just websites, if photographs are used, the office is now saying that any sort of photographs of labels or tags should actually be attached to the goods, with the idea being that you can see the goods, you can see the label attached to the goods. And the office is concerned that they want to be sure that the specimen submitted shows use of the mark as a consumer would see the mark. So the office can verify that marks are actually being used as trademarks and that consumers are seeing those marks, and thereby the marks are actually in use in U.S. commerce. The guidelines also discuss, and this is not new, this has always been the rule, but also discuss material that is not acceptable for specimens of use, and these include material that really a consumer wouldn't see. So artist renderings, any sorts of printers proofs, or mock-ups, digital imaging, or such uses of the mark for internal purposes, but not necessarily for consumer-facing purposes. So these guidelines just reinforce the idea that any sort of specimen that's submitted needs to be something that a consumer sees. Okay, Examination Guide 220. This deals with marks that include geographic wording where that geographic wording does not indicate geographic origin, but it still has significance. And this guideline specifically relates to cheeses and processed meats. And my slide has a couple of examples of marks or wording that falls within this guideline. Bologna, that for processed meat doesn't necessarily have to come from the city of Bologna, but it still has to meet certain sort of standards in order to be called Bologna. And cheddar cheese doesn't necessarily come from the city of Cheddar in England, but it's still, in order to be called cheddar cheese, needs to comply with various requirements. So what these are called are standards of identity, and it means that these words, these geographic words, still have meaning, and they signify that the products, the meat and cheeses being provided using these marks or under these, being labeled as with these terms, meet certain production methods and have certain ingredients. But again, these terms do not indicate geographic origin. So the FDA keeps a list of standards of identity for cheeses. The USDA keeps a standard of list for processed meats. And agencies of the UN and WHO keep lists of standards of identity for international requirements for certain cheeses to be called by certain names. And so these guidelines, the new guidelines now require examining attorneys when doing searches for trademarks and applications that are filed with the office to do standard searching, but also search standards of identity in the FDA, USDA type databases to see whether or not the marks that are filed that include terms that may have geo-significance actually relate to cheeses and meats, and actually whether those terms do have significance. And the guidelines then require, if a term is used that is listed as a standard of identity, the examining attorney must require a disclaimer of that term or refuse the term if the entire mark is descriptive or generic. The guidelines also state that inclusion on these lists is a pretty good indication that the term is generic for that particular cheese or meat. And the guidelines point out that marks using these standards of identity terms need to be non-deceptive. And so to the extent somebody files a trademark application that incorporates the term cheddar for cheese, the trademark examining attorney will require that the applicant amend the goods identification to not just cheese, but to cheddar cheese. And if the applicant can't do that in good faith, then the office will issue a deceptiveness refusal. Okay, that is all we have for today. And on behalf of Nicole and myself, and Nicole can chime in if she wants, but we would just like to thank everybody for attending. Please stay safe, and we look forward to doing this again mid-year next year.
Yep, likewise. Thanks, everyone.